So, as we have mentioned earlier, we have explained several areas of digital law conducted. We have already tackled the internet law, and now we are heading towards software law. The law of software. In today's digital age, computer software plays a pivotal role in our lives, from mobile applications to operating systems. Software has become an integral part of our daily routines. With the rapid advancements in technology, a question arises: what are the legal mechanisms for software protections? So, dear students, what is a software? It is a collection of instructions, programs, or code that directs a computer or digital device to perform specific functions or tasks. It can encompass operating systems, applications, utilities, and other programs designed to facilitate various computing operations. So, from a legal standpoint, software can be protected under copyright law, patent law, and trade secret law. Depending on the nature of the software and the specific legal protections it may be eligible for. Legal considerations surrounding software often include issues related to licensing, distribution, intellectual property rights, and liability for software defects or malfunctions. In legal terms, software is a work of the mind protected by the Intellectual Property Code (IPC) with the title, authors, and associated rights. Intellectual property, IP. It refers to any creations of the mind, such as inventions, literary and artistic works, designs, symbols, names, and images used in commerce. It is a category of property that includes intangible creations, and it allows individuals or organizations to have exclusive rights to the use of their own creations. So it is the creation of the mind. So, dear students, the IP is introduced through two different types: literary and artistic property and industrial property. Let's check literary and artistic property that is protected by copyrights and related rights. For example, this is implemented on films, music, artistic works, and architectural design. Let's talk about industrial property, which is applied through patents, industrial designs, trademarks, or geographical indications. So the legal protection of software is introduced through three different aspects. The first one is copyright protection, the second one is patent protection, and the third one is trademark protection. So first of all, we're going to talk about copyright law. Copyright law protection. It is a legal mechanism that grants exclusive rights to the creators of original works. It protects various forms of artistic and intellectual expression, including literature, music, films, and even software. The objective of copyright law is to encourage creativity and innovation by providing creators with the means to control and profit from their creations. Okay, so in order to provide them with the copyright protection, software has been assimilated to literary and artistic works. In the same way that the author of a book creates it gradually through the words, lines, and paragraphs that he writes, the author of a software creates code that he structures and composes to create his software work. Copyright protects computer software, specifically the program code, as a literary work. Other sorts of copyright works may also be related with some computer software. Graphic user interfaces or portions of them, for example, may be protected as artistic works. Some animated graphical sequences may be called films, and music connected with software such as games software may be a copyright work. Database rights can also be useful for safeguarding computer programs. In 1980, Congress amended the 1976 Copyright Act to include a definition of computer program. In the Third Circuit Court of Appeals case, the court in Apple Computer Inc. v. Franklin Computer Corp. 1983 confirmed that computer programs are in fact literary works protected under the Copyright Act. The court held that a computer program, whether in object code or source code, is a literary work and is protected from unauthorized copying, whether from its object or source code. So, copyright protects the form and not the ideas. This principle means that only the formatting of the software is protected, not the idea that it implements. For example, the idea of software providing road information to tourists is not protectable. The conditions of copyright protections. We have two conditions, originality and tangibility. So, number one, originality. The software must be an original creation of the author and should not be a copy of existing software. Tangible. The software must be written down or recorded in some way. Application of copyright. It means how do we apply the copyright? So copyright applies to creative works only. It is an exclusive right that is granted to the person who created the work. The work is protected automatically once it is created. It is not necessary to register a work for it to be protected by copyright. Application of copyright protections does not depend on publishing or being available to the public. Who is the legal owner of the rights? In most cases, the legal ownership of software program belongs to the programmer who created it. However, if the programmer develops the software while working for an employer, the employer typically owns the rights unless otherwise agreed upon between the two parties. The rights to the software can be freely transferred, enabling the specification of ownership in contracts between independent programmers and clients. Companies with software rights can sell those rights to other companies, but such transactions must be documented in writing in multiple member states. When one programmer modifies another's program, it is critical to seek approval from the rights holder. Determining ownership of the modified program can be complex. It's best to assume that both the original author or employer and the modifier or employer hold separate copyrights for the modified program, necessitating permission from both parties. Let's move to types of rights. Number one, moral rights. Non-economic rights that are personal to the author. For example, you have the right of paternity, name attribution, the right to be acknowledged as an author of the work. The right of integrity, the right that the work not be mutilated or distorted. The right of withdrawal, the right to decide what and in what form the work will be presented. Let's move to economic rights. The rights that enable the author or creator to financially benefit from their work. Here we have the right of reproduction. This allows the right holder to make copies of the work. The right of distribution. This grants the right holder the authority to distribute copies of the work to the public. The right of public performance. This allows the right holder to present the work in public. Alright, let's move now to the next step, and we're going to talk about some exceptions in the software copyright. If you legally obtain a computer program with the right owner's permission, certain actions are permitted. Further details are provided. The use of the software for its intended purpose. The ability to rectify program faults. Creating a backup copy for accidental damage prevention. Conducting research and testing. The recompilation right exclusively relevant to computer programmers. Question: what occurs when a software license agreement includes clauses that demand the consumer to waive their rights? Is it accurate that these license terms hold validity? Alright, the answer is, unfortunately, legal aspects are still ambiguous. While certain restrictions are enforceable, others may be not, depending on the perspective. For instance, a license limiting software use to a single device is generally considered legally valid, while a clause that prohibits creating backup copies is typically invalid. If you have uncertainties, seek advice from a legal professional and consider the license terms valid until informed otherwise. The duration of a copyright validity. The duration of a protection varies according to the law in force in each country, depending on who created the work and the type of work itself. The work is protected throughout the author's life and for 50 years after their death in countries party to the Berne Conventions, or up to 90 years in some countries. For example, here we're going to mention Switzerland as a 70 years protection. Upon the author's death, the economic rights are transferred to their heirs. If there are multiple authors, the end of copyright is calculated based on the death of the last surviving co-author. If the author is anonymous or has used a pseudonym without any knowing who they are, the duration of copyright is calculated from the moment the work is published. The same regime applies if the author is a corporation or an institution. When the protection period comes to an end, the work falls into the public domain, which means that everyone can reproduce it freely. However, no one can claim authorship of a work whose creator has died. It should not be forgotten that an author's moral rights are unlimited. Let's talk about the copyright protection in Algeria. The collective management of rights related to literary and artistic poetry is entrusted to the National Office of Copyright and Neighboring Rights, ONDA, a non-profit association subsidized by the Ministry of Information and Culture. Here is an extract from the laws that have been introduced on onda.dz. For reference, you can check the website. Now, to go for furthermore information on copyright in Algeria, you must consult the site of Ministry of Culture and Arts. For more references, you need to check these websites. Alright, now let's move to license agreement. Article L335(2) of the Intellectual Property Code states, any person who uses, copies, modifies, or distributes software without explicit authorization from the holder of the economic rights is guilty of infringement and liable to 3 years imprisonment and a fine of 300,000 euros. This extract is from the website CPI France as a reference. If there is no explicit right granted, using software constitutes infringement. Licenses. Licenses are contracts that protect authors, users, and potential collaborators in development. They grant rights and often impose obligations that must be adhered to. A software license agreement is a legal contract between the software developer or vendor and the end user. It outlines the terms and conditions under which the end user may use the software. This agreement specifies the rights and limitations regarding the software's use, distribution, modification, and any associated liabilities. Understanding and adhering to the terms outlined in the software license agreement are crucial for both parties to ensure compliance with legal obligations and avoid potential disputes. Indeed, among all the documents provided with software, the license agreement is the only legal proof that you are entitled to use the software. That is why it is essential to keep the license agreement as long as you possess the software. Let's move to types of license agreements. You have got number 1, copyright, and number 2, copyleft. What are the copyright and copyleft? Number 1, copyright. It grants creators exclusive rights to their works for a limited time. Copyright restricts usage. However, copyleft is a method for making works free and ensuring that modified versions also remain free, typically applied to software and open source projects, promotes collaborative development and freedom to use and modify. Let's get started to explain the free licenses. Free licenses offer the possibility to use the work for any purpose, the possibility to study the work, the possibility to redistribute copies of the work, the possibility to modify the work and publish these modifications. In some cases, this license may require that any copy or derivative work be distributed under the same license. This is known as copyleft or sharing under the same initial conditions. The development of open software accelerated in 1991 when a Finnish student, Linus Torvalds, launched a project called Linux, inviting all voluntary programs or programmers to participate via the internet. The success of this approach destabilized commercial providers. Open software is not the product of a single company or individual. It is created by a whole community composed of companies, like for example Red Hat, or associations like for example the Free Software Foundation, and individuals. It belongs to everyone. Without exception, anyone can contribute by reporting back, suggesting ideas or programming for those who know how to code. All actors in the open software world, whether they are companies, developers, or simple users, are all equal and enjoy the same rights. Let's explain the open world of the software. We have two elements, the users and the developers, and the relationship between the two here is a complementary relationship, since the user studies and uses the program, and the developer helps and gives hand to the users whenever it's needed. So the developer develops the software and the user uses and studies the software. So the developer here listens to what the users need. Okay, let's move to proprietary licenses, closed sources. All rights are reserved by their holder. This is the case for the majority of commercial software. In almost all cases for these software, the client owns only the medium, not the software it contains. The suppliers can stop maintaining the software at any time. The concept of proprietary software is complementary to that of free software. Proprietary software is defined as non-free software. In the most common case, the purchaser of proprietary software must accept an end-user license agreement that gives them only the right to use a single copy of the software. Alright, developers have the power to create their software as they wish, and users have only the choice to accept or refuse these software products. If a software crashes, you are forced to wait for the company to fix the bug, hoping that they will do it quickly and not charge for the correction. These companies have all the power over their users, who themselves are powerless. As you can see in the proprietary license, there are two elements. The first one is the closed source company, and the second one is the user, where the company here sells the product or the software to the users, and the users accept the fact that they have bought the product or the software. As we can see, the company and the users are separated, or the consumer are separated from each other. That's why the company is in a position of a powerful position, yet the consumer is powerless. So within the license agreement, we have the closed source and the open source. Between these two, we have 4 actions. Within the closed source, the 4 actions must be limited and prohibited, yet in the open source, they are freely used. What are these 4 actions? First of all, you have the freedom to run the program for any purpose. Number 2, the freedom to study how the program works and adapt it to one's needs. Number 3, the freedom is to redistribute copies. The freedom to improve the program and release these improvements, and for this access to the source code as a 4th element. Question: specify the advantages and disadvantages of each type of license, closed source and open source. We've already seen that the software should be reserved through 3 different laws. The first one, it was the copyright law. The second one, it was the patent law. And the third one, it was the trademark law. We've already covered and explained the copyright. And now we're heading to the patent law. The patent protection. Despite the fact that copyright is the natural protection for software, it is increasingly becoming the subject of patent applications. A patent is defined as a technical solution to a technical problem, such as ABS brakes. The invention must be feasible and not consist of the statement of an abstract principle. Hence, an idea cannot be patented. Only the means to materialize these ideas can be patented. Patents can only be obtained for inventions which are technical solutions to technical problems. They can generally be obtained in any technological field. Indeed, the technical nature is what distinguishes objects protected by patents from objects protected by other intellectual property rights, literary and artistic works, trademarks, designs, etc. Alright, now we're going to talk about categories of inventions. The first category is the product invention, and the second one is the process invention. Let's explain each side. So number one, product invention. It concerns a specific physical entity with a particular mechanical composition or chemical structure. Number two, the process invention. It involves an intangible method, a way of doing something, a formula or a sequence of operations, or even a single operation that leads to a known or a new result or product. There are three conditions that must be available in order to achieve the patent protection. Number one, the novelty. Number two, susceptible to industrial application. And the third one, it involves inventive activity. Let's explain each one of them. Novelty. The invention must be new and not part of the existing body of knowledge in its field. This means that the invention should not have been publicly disclosed or patented before the filing date of the patent application. Number two, it must be capable of being manufactured or used in any type of industry. Number three, it must not result in an obvious manner from the techniques known to a person skilled in the art. Formalities. Unlike copyright, which is acquired systematically free of charge and without formalities, patents are obtained only through the filing of an application, adherence to a procedure, and the payment of fees. The patent is further maintained annually by the payment of annuities. There are three possible routes for filing a patent. Number one, or the first one, is the national filing. Filing a patent application directly with the National Patent Office of the specific country where protection is sought. For example, filing a French patent application with the French National Institution of Industrial Property. The second one, the European filing. Filing a patent application with the European Patent Office for a European patent. This provides protection in multiple European countries that are part of the European Patent Convention, which currently includes 38 member states. The third one, international filing. Filing an international patent application under the Patent Cooperation Treaty, PCT. With the PCT, application does not grant a patent but allows the applicant to seek patent protection with intellectual property organization in multiple countries by filing a single international application. The PCT process provides a centralized and streamlined approach before entering the national phase in individual countries. Let's talk about our beloved country, which is Algeria. Let's ask this question. What is the patent office in Algeria? And what is the procedure to obtain a patent in this country? This is going to be a homework for you, dear students. I'll provide you with this PDF as a resource or a reference to find the solution. The legislative texts traditionally provide lists of elements that are not considered inventions and therefore cannot be the subject of patents. Not patentable. Scientific discoveries, but their application may be. Aesthetic creations. plans, principles and methods, rules of games, presentations of the information, computer programs, animal breeds or plant species, treatment and diagnostic methods for humans or animals. The EPO, or the European Patent Office, does not grant patents for computer programs or business methods that do not provide any technical contribution. Computer programs as such are excluded from patentability. In accordance with this law, a computer program is not patentable if it does not bring about an additional technical effect that goes beyond the technical interactions inherent between software and hardware. On the other hand, an invention implemented by a computer, even in the form of a computer program, that can provide this additional technical effect may be patentable, provided it meets other patentability conditions such as novelty and inventive step. In this case, it will be recognized as providing a technical solution to a technical problem. Okay, let's go to software can initially be the subject of a patent when it pertains to an object incorporating software or a technical process whose execution is carried out through software. The software is then only part of the targeted invention. An exemplary case of this type of scenario is the ABS type braking system seen in automobiles, which is electronically managed by integrated software. However, the APO goes further and accepts the patenting of software even when installed on computers as conventional programs, provided that their effect is a technical effect going beyond the effects resulting from the use of software on the computer. Ownership of the patent. The right to a European patent belongs to the inventor or his successor in title. According to the APO, European Patent Office, if the inventor is an employee, the right to the European patent is determined by the law of the state in which the employee carries out his principal activity. In the absence of contractual clauses, case law makes a distinction between service inventions, mixed inventions, and free inventions. There are three types of inventions. The first one is the service invention, the second one is the free invention, and the third one is mixed inventions. Let's introduce each apart. Service inventions. These are inventions made in the performance of the creative task or implicitly assigned to the employee by the employer. These inventions are automatically considered the property of the employer. Second one, these are inventions made by the employee outside of his employment activities, and with his own resources. These inventions are considered solely the property of the employee. And the third one, which is the mixed inventions. These are inventions that do not fall within the scope of the employee's assigned tasks but were made using material or intellectual resources provided by the employer. It will be up to the judge to settle the dispute based on the characteristic of the specific case. The third one, or the third law that preserves the software, which is the trademark law. The trademark is a distinctive sign that allows for the identification of the origin of a product or a service. The purpose of the trademark is to ensure that anyone purchasing a product or service from a specific brand can be confident that another product or service bearing the same mark comes from the same manufacturer or service provider. It also serves an advertising function, as a person who has been satisfied with a product or service from a specific brand is likely to seek the same product and/or service and recommend it. Therefore, trademark law is a right that grants its holders exclusivity in the use of the trademark in business for specific products or services. Any sign capable of graphic representation can become a trademark if it serves a distinguished product or services. For example, we have a verbal sign pronounceable like Yahoo, Disney, Lacoste, a figurative sign logo like Renault's diamond or Lacoste's crocodile, a complex mark formed by the combination of elements such as a logo and a verbal sign crocodile plus Lacoste, a slogan like Lacoste's slogan which says Lacoste life is a beautiful sport, a sound, the melody or the jingle of a radio station. And for example, we have here the Nokia tune. And the three-dimensional shape, the shape of Toblerone chocolates. The last one, the color shade, which is the yellow for the Kodak. So in here, guys, I have provided you with a very famous and well-known trademark, which is a complex trademark in this situation that provided the three elements that we have mentioned earlier. Now let's move to characteristic of the trademark. So number one, you have the lawfulness of the trademark, which is divided into three parts: not contrary to public order and good morals, compliance with laws or rules, and then we have non-deceptive. So let's explain each one aside. Number one, not contrary to public order and good morals. The trademark should not go against public order or accepted moral standards. Compliance with laws or rules. It should not violate specific laws or regulations. Non-deceptive. The trademark must not be deceptive and should not mislead the public. Distinctiveness of the trademark. It should be original, which means the chosen sign for the trademark should be original, avoiding common, usual, or descriptive terms. Number two, it should be available, and we have provided availability in the second one. The trademark must be available, meaning it does not infringe on existing prior rights. This often involves conducting a thorough search for prior trademarks or similar rights. Conditions of validity. Availability. It must not infringe on prior rights including trademarks and other distinctive signs, copyright, personality rights of a third party, right to the name, reputation of a territorial community, right to a geographical name constituting a protected geographical indication or an appellation of origin, names of websites, associations, etc. I'll provide you with a comparison in this table between the object protection, the scope protection, conditions, and duration for the copyright, copyleft, and the trademark. And by the end of this presentation, I have provided you with references or the elements I have used in my presentation or to bring to you this presentation. These books are available on internet as PDFs. Try to check them for further details. Thank you for your attention and see you in the next presentation.